the recent pension judgments which have come, and also the kind of alternatives which have been tom-tommed by the union government in the form of the unified pension scheme. Most of us who joined in and around 2004 and got our confirmation after 2004, we have been pushed into the new pension scheme for the last 20 years. Since then, various employees organizations and also various teachers, they went to the court to seek relief, because though their confirmation happened after 1st January 2004, most of them had joined the profession before that. And so, as a recent judgment has pointed out, the definition of new entrant does not hold on anybody who joined their first profession before 1/1/2004. However, despite getting relief from various court judgments, the teachers yet are to be given allotted the old pension scheme. So we have with us two panelists, both teacher activists and those who have been at the forefront of struggles in their university. We have Professor Avinash Kumar from Center for Social Sciences, School of Social Sciences, JNU. Avinash has been the JNUTA secretary. He has been one of the face of the JNU teachers' struggle against a draconian administration, both in the last and in the current administration. And Avinash has done extensive work on the issue of pension. So he's the first speaker today. He's the first panelist who will talk about the different court judgments. We also have with us Professor Surajit Mazumdar, again from the School of Social Sciences. Professor Surajit Mazumdar has been an economist. He taught at Hindu College for a very long time. He was the secretary of the Democratic Teachers Front in 2007 when he left Hindu College and later joined JNU in 2015. Professor Surajit Mazumdar was also the JNUTA secretary. He was also a member of the JNU Executive Council. So we welcome both the panelists, Dr. Avinash Kumar and Professor Surajit Mazumdar, among us, who will give their own take on the issues which we have flagged here, namely the court judgments which would possibly give relief to many of us, and also the hoax which has come in the name of the unified pension scheme. So Avinash, you are the first person. You have the forum with you.
Thank you, Rudrashish. Thank you so much for inviting me. Thank you, the Democratic Teachers Front, for hosting this, because this is a very important issue, and the teachers movement has been kind of struggling and raising this demand ever since this new hoax of the NPS had come in 2004, and subsequently now you see that there is this new another hoax being being pushed down to us in terms of what is being told as UPS. Now, ideally, I would have liked that Surajit would have gone first, but I presume that it is also important that, and this is what Abba told me, that it is also important to understand what has been the recent court developments, and therefore have been put first. But I would sort of like to place the context. So I would like to share the screen so that it becomes easier for those participating online to understand what is being said here. Yeah. Okay. Okay. Yes. So basically, what is being discussed is, as the title of the discussion itself says, towards the old pension scheme. And I would like to place, although we are discussing the court orders, the recent court judgments, I would like to place this argument in the demand that our larger demand remains that we want the restoration of the old pension scheme. And why do we want that restoration of old pension scheme is based on a kind of a very sort of a legitimate demand that we have, the teachers movement has been raising, and also the other sort of employees associations have been raising, in the context that we have to understand that pension cannot be seen as a gift granted to us by the government. It's actually the legitimate part of our lifetime earnings, which we give during our service years. And therefore, it is very important for us to understand that pension is not something that we are demanding as something as a post-retirement sort of benefit without actually legitimately sort of working and claiming for it. So we have to be very clear on that demand. So therefore, the larger demand about restoration of OPS is very important. And before I go into the intricacies of the legal setup, I wanted to put this, place this, before us. The second important part is that when we look at this transition from OPS to NPS, so we must understand that any kind of reduction in pensionary benefits that is being pushed down to us is actually, in a larger sense, amounts to a pay cut. So, which may not appear to us in the current form, but actually it's a pay cut because it is our savings from the sort of current, which we are not being paid now, which has been promised for our pension. So we have to understand that why it is a pay cut, and Surajit will explain that in a better way. But I'm just trying to put it in the context that that my arguments and my sort of placement of the court judgment should not be seen as an amount to say that okay, we are satisfied with this transition from okay, some people, those who joined before, but those who have not joined after 2004 qualifies for that, but the others will not. So that's the larger sort of a question. And you have to also understand it from the perspective that the kind of sort of submission that the government is making in the courts on behalf through the institutions that they represent. It's actually also telling us that while on the one hand they have been forced to accept that NPS was a flawed scheme, and therefore there is a need to redesign it, and therefore they are now trying to put it as a new hoax of UPS. But at the same time, they are also trying and showing the reluctance to accept that UPS is not equal to OPS, and therefore our demand is very strong that we should not accept UPS as OPS, and we should not accept this attempt of trying to shove NPS UPS down our throat as the government is trying. So I'm trying to place the court orders, and I'm trying to understand how the state is trying to sort of act as an agent of the new liberal regime in order to push this down our throat. And that's where I want to sort of place as. Now, when I say pension is not a sort of a gift or a dole, it's a statutory right. It's not just me who is saying that. And therefore, the version of the court becomes very, very important. And you can see that in several judgments, I'm not quoting here how many of them, but in several judgments, the courts have clearly observed that the right of the government servants to receive pension is not a bounty. It is a statutory right conferred under the pension rules. Now, I'm just quoting one Supreme Court judgment in 2013, and then I will give you another court judgment when I conclude in 2023. But to start with, in 2013, the Supreme Court actually went to the extent. I mean, we may agree with the interpretation, but we may not agree that. But it says that the right to receive pension, gratuity, or leave encashment can be treated as a right to property in terms of Article 300A of the Constitution of India. Now, we may have our differences of opinion on the right to property, but I'm saying that the Supreme Court has actually made it very clear that how this statutory right is not a bounty, and it is any violation of that through reading it in a narrow interpretation of rules actually amounts to a violation of Article 300A of the Constitution of India. So therefore, this positioning of the pension, this positioning of the sort of the current arguments which I'm going to use the court judgments has to be seen in this light, that any kind of a narrow interpretation of even the existing rules, of course, this whole transition from OPS to NPS itself is questionable. But even when that transition is happening, how a narrower interpretation of that rule is actually in violation of Article 300A. This has already been said by the Supreme Court of India. Now, I'll after that come to the I'm using two recent court judgments where the court has actually restored the OPS in the case of petition, and all these are cases of Delhi High Court. Now I'm taking these two cases only to make a point, because both these cases the petitioners are from Delhi University, and therefore I'm using this. Although I have a a lot number of other cases from Jamia and from other universities where and they are also in Delhi High Court, but I'm not using that. Only to give you a sense about, because there are statutes which governs universities in different ways, and therefore I'm using these as an example to say how Delhi High Court has looked at this and looked at the working and the rules governing the services in Delhi University, and has given an interpretation which is based on. So you have the three petitions in the first judgment, which were all clubbed because all there was similar, and there was the most recent one was in 25th July 2024, which was again a similar judgment. And in the judgment of the second one, the Delhi High Court has actually used the previous judgment and said. Now, let me also qualify it here that after the first judgment in 2023, Delhi University has actually challenged this judgment in the divisional bench of the Delhi High Court. But even when they challenged it, the divisional bench did not give a stay on the order of the Delhi single bench, court, and therefore the learned judge of the single bench actually is continuing to give the orders, because she has clearly stated in the second order, since the order of the single bench is not stayed, therefore that order remains implementable, and therefore she is going ahead with this order. And based on this, she has given many other orders, but I'm limiting myself to these two. Now, these are the cases in which colleagues from Delhi University have been teaching in different colleges and different departments of the universities prior to 2004, as Rudrashis was trying to point out, including his own case, that they have been teaching in Delhi University prior to 2004, but they became permanent, or they were absorbed or became permanent only after 2004. And hence there is a big sort of a debate about that who is this new entrant. So whether those who were teaching in Delhi University in other colleges, or even outside Delhi universities, whether they should be considered as and they were made permanent after 2004, whether they should be considered as new entrant, or actually they are already serving employees and they cannot be considered under new entrant, and hence they are eligible for the old pension scheme. In that, therefore, there is this whole debate of the whole judgment, if you read that judgment carefully, is based on examining and interpreting the expression that who is new, what is a new entrant in the new pension scheme. And before I go on to the explanation about how the judgment has been arrived at this conclusion, I want to give you the conclusion of the judgment, and which is very clearly written here. The Delhi High Court writes that it is an irresistible conclusion that the entire service of the petitioners from the date of initial appointments on temporary basis till the date of regularization shall be counted as qualifying service. Now, this qualifying service is also a very important term, and I'll come back to that in a while, but should be counted as qualifying service for the purpose of pension, and they will be deemed to be in service prior to 1st of January 2024, when the new pension scheme comes into action, comes into implementation, and they should be governed by old pension scheme. Now, I'm not getting into the different scenarios of different petitioners in terms of how some of them were actually, already being covered. Their gratuity were being deducted, but subsequently all those were withdrawn. And this is what the university and the state, is actually arguing that no, that was a flawed thing, and because we had done it earlier as a mistake, so we were rectifying now. But the court was very clear, and very clear by repeating its order, that it is palpably clear that courts have repeatedly affirmed that if an employee enters service prior to 1st of January 2004, that is the date of enforcement of NPS, in whatever capacity, and I'm emphasizing that, therefore I've made it in bold, in whatever capacity, whether as temporary or ad hoc employee, and renders continuous and uninterrupted service followed by regularization absorption, the period of service shall count towards qualifying service for pension, and such an employee will be deemed to be in service prior to 1st January 2004, and thus governed by OPS. So the conclusion is very clear. This was repeated in 2023 by Delhi High Court, and once again in 2024, this year in July. But the point is that when the court says that it has been repeatedly affirmed, what are the cases where it has been, using that it has been repeatedly affirmed? So therefore, I'm trying to, give you a snapshot of three or four important judgments. The fourth one is the, Supreme Court judgment, which came. So I have not listed here, but that's also important, which I'll conclude, when I'm, towards the end of my session. So there are three important judgments, and these three are very, very important. One is the Madras High Court judgment in K. Punayakoti and others in 2014. The other is the division bench of the Delhi High Court, again in 2010. And the third one, which is also very interesting and relevant for us, particularly in Delhi University and for others as well, is the Punjab and Haryana High Court in Dr. Neelam Agrawal and others. Now, what was the repeated affirmation, and how these three court judgments are very important for us to understand? And it is important for us to understand these judgments, not just the Delhi High Court judgment, because these are the basis on which the court is, sort of addressing this. Now, the idea, the definition, and the affirmation that what is a new entrant actually is being confirmed and settled in the Madras High Court, judgment in K. Punayakoti in 2014, which clearly says that a person already in service as contingent or temporary staff working continuously and absorbed in permanent establishment on or after 1st January 2004 cannot be termed as new entrant into service. Therefore, NPS can be applied only to persons appointed for the first time as casual, temporary, or permanent on or after 1st January 2004. The court clearly ruled in the favor of the respondents and dismissed the writ petition filed by the department, and ruled that the respondents, though appointed as casual laborers, and I'm talking about, the appeal is including the casual laborers, and were granted temporary status subsequently from 31st December 1999, but they cannot be denied the benefit of OPS only because they were only absorbed permanently in 2005. Okay, so that clearly establishes that the definition of new entrant is not about being permanent after 2004, right? It is about those who are coming for the first time into service. Anyone who is continuing with the service, in whether in ad hoc, in temporary, or in any other form in contractual positions, cannot be classified as new entrant, and Delhi High Court has reaffirmed it in many ways. Now, the second judgment, in which this is a division bench judgment, not a single bench, and here once again, the court is actually upholding the order of the tribunal, which is placing reliance on the Rule 13 of the pension rules, which categorically stipulates, as I said, qualifying service. Okay, qualifying service of a government servant commences from the date he joins in a temporary capacity, provided that the temporary service is followed without interruption by substantive appointment in the same or another service or post. So as I said, even if you may not be teaching in one college, same college, and if you have, but it is in continuity, then it would qualify to be governed, qualified to be classified as qualifying service. And it also says it very clearly that though NPS was introduced on 1st of January 2004, Rule 13 of the pension rules were not abrogated by NPS, and therefore that scheme is not applicable to the old. It is only applicable to the new entrants in the government service, and they cannot take away the rights of the old entrants prior to 2010. Now, so once again, it clearly establishes that. I will explain what Rule 13 of the pension rule is. I'll go there in a while, but I want to reiterate, and I want to go back. This is also a case in which, in the Postgraduate Institute of Medical and Educational Research in Chandigarh, PGIMER, the Punjab and Haryana High Court also, this is looking at different dates. People were appointed as on ad hoc basis in PGIMR on different dates between 1996 and 2003 as lecturers, and were regularized on various between 2005 and 2011. And the tribunal had actually ordered in their favor, which was challenged by the administration. And therefore, this again upheld that judgment, and it says that for the purpose of the pensionary benefits, the qualifying service of the applicants shall commence from the date they took charge of the posts to which they were first appointed, and I'm emphasizing in temporary capacity, as that temporary service was followed without interruption by substantive permanent appointments in the same service posts as contemplated by Rule 13 of Central Service Pension Rules 1972. Now, this is clearly reinstating and reaffirming the position that anyone who has been already serving, whether in the capacity of a, in temporary or ad hoc or contractual position, but has been made permanent in the same post or in other service, but as a continuation of that, should be treated as a part of the qualifying service, and they cannot be treated as new entrants. Now, this particular judgment, Punjab and Haryana High Court judgment, is also very important and relevant for us because of a very important remark that it made. And this is in the context of the picture that I have placed here. I mean, many of us remember that in 2000, last year, I think this was, in the context anticipation of the elections, and that the government DOPT order had come where it was said that even if you were actually made permanent after 2004, but if your advertisement was notified and for recruitment on or before 22nd December 2003, then you are also eligible for that. That later it was withdrawn, and it was said that the UGC has not accepted it, and therefore it is not being implemented in autonomous bodies. But that itself is a trick that they have played, and we have to sort of again demand that this should be implemented. But I'm using this in order to show that how even this is kind of covered, because the remark that the Punjab and Haryana High Court made is very relevant. It said that all these faculty members were on ad hoc basis for a long period and could not be regularized prior to 1st of January 2004 had the selection committee met earlier, meaning thereby, had the meeting of the governing body was timely held, then the service of the applicants would have been regularized much prior thereto. In other words, since the respondents failed to convene the timely meeting of the governing body, so the applicants cannot be possibly be blamed. So anyone, if you use the larger meaning of this particular sort of observation by the court, which is part of the order, it's not just an oral observation, it's part of the order, that you cannot blame the petitioners, the applicants, for denying them late. So all those people who have been teaching in as ad hoc and temporary and have been made permanent post 2004 can actually claim that it is not their fault that they could not be, because they have been teaching, they have been doing the same duty as they have been doing, they are doing after being made permanent, even before they were made so. So that's a clear sort of a very solid sort of argument, and very solid, which can be used by all of us in our sort of arguments to make it. Now, what is the provision of the Rule 13 of the pension? Now it is very clearly counted. It is said that Rule 13 of the pension rule do not envisage exclusion of the service rendered on temporary or ad hoc basis as long as the same is uninterrupted. So this is the clause that the courts are ruling, reiterating time and again, that provisions of Rule 13 do not envisage exclusion of the service rendered on temporary or ad hoc basis as long as the same is uninterrupted and culminates into absorption and regularization. Therefore, the period of that service is liable to be counted towards qualifying service for pensionary benefits. And once that is done, it would be wholly illogical to treat such an employee as a fresh appointment post 1st January 2004, if the entire temporary ad hoc service was prior to the cutoff date of 2004. Now, in the recent case, I'm sure a lot of our colleagues here from the university have witnessed that when the recent promotions were happening, several of their past service have been counted. And remember that Rule 17 of the pension rules were only made to affirm that the counting of the past service is primarily done to give you the pensionary benefits. So counting of the past service is not done merely for giving you the dates of promotion. Of course, that becomes subsequent. once it is counted as a, as part of the pensionary benefits, you are, of course, will be given all the promotion benefits, and from the, your date of eligibility will be shifted because of that, because you have already served in different capacities. So it is clearly a point which the pension rules in the existing system makes you, and this is what we must sort of use it. Now, what is additional, and this we must all know, that the Delhi High Court, in addition to the other court judgments that we quoted, the first three ones, the Madras High Court, the Delhi High Court's divisional bench, and also the Punjab and Haryana High Court, what they have also said, that Delhi factor in favor of the respondent, of the petitioners. And what is the added factor? Added factor is that services in Delhi University are indisputably governed by Statute 28A, which actually tells you what is the qualifying service. And that qualifying service is defined in clause 1H, which clearly says that it is, primarily a sort of a replica of the Rule 13 of the pension rule in terms of the commencement of the service and inclusion of service rendered in temporary capacity. Now, temporary capacity does not mean what is being used in Delhi University as different services, temporary service, ad hoc services. Temporary capacity includes all services. It's not just those services which is written as temporary appointments. No, ad hoc appointments, leave, appointment against leave. If you are, and there is a case in this, in one of the petitioners was appointed against leave vacancy and then was made permanent in the same post, and even that particular case was treated as part of the temporary service and was given OPS benefit in one of those petitions. Now, so I'm repeating this, that Statute 28 clearly provides, clause 1H, that service rendered by a person on a full-time basis in the university in a temporary capacity without interruption and followed by confirmation shall be counted as qualifying service. So I think what is important for us also is that we also try and each one of us read the what is Statute 28 of the university, how the qualifying service has been defined, and how we should use that, because as you know, Delhi University has not, despite the clear court verdict, Delhi University has not implemented and has challenged the judgment. So of course, in terms of the judgment, in terms of its implementation, they have not yet accepted it. But what is very important for us is that the single bench of the Delhi High Court has constantly said that since that order has not been stayed, therefore it is important, she is actually delivering all judgments. There is a similar judgment in case of Jamia, which I have not quoted here, but I have read it. And it has been said there also that the university should look into all such cases in which people serving on temporary basis prior to 2004 must be given. Now, I said about the last judgment of the Supreme Court, and I'm going to quote the Supreme Court judgment, which is as recent as in 2023. It was once again a petition in which past service of the contractual employees was questioned. And once again, even in that case, the tribunal had actually given a verdict in the favor of the petitioner, and subsequently the Himachal Pradesh High Court also upheld that judgment, but that was challenged by the state of Himachal Pradesh. And in that case, the Supreme Court has reaffirmed that that Rule 17, and I'm quoting that Rule 17 was engrafted essentially to cater to the eventuality where the employees working on contract basis were regularized at a later stage. It is only for the purposes of pensions that the past service as a contractual employee is to be taken into account. And in that case, again, Supreme Court has upheld the past service, ordered the state to take into account for pension the past service, and they also will be covered under the OPS scheme. Now, this is a kind of a small kind of a snapshot which I gave, and I'm sure you would agree that each one of you, if you read the judgment, you will get more. And all these judgments are easily available. I have shared the two which was shared with the link, but there are multiple other judgments. If everyone wants, I can share the other three judgments which I have quoted here now, and I can sort of take more questions if there are more to clarify. But the point I wanted to sort of establish here through these court judgments is that a whole lot of colleague from Delhi University has been teaching for a long period of time as ad hoc, who were made permanent only after 2004, because there was for a long period of time there was no permanent appointments being made. Now, if you look at read the judgments of the Punjab and Haryana High Court, that has clearly established that it is not the fault of the applicant. Hence, each of those applicants can actually appeal, can actually approach the court with that particular order, and the current two High Court, Delhi High Court orders, and the the divisional bench order, and clearly make a case that they are really qualified to be counted as qualifying service. And I mean, and the more the pressure will mount on the state, the more the stronger the movement will be, and it will help us to strengthen our argument, strengthen our demand. That it is, I mean, of course, what we are talking about is only about those people who have joined. But as I said, the larger demand about the restoration of OPS is a connecting point, and this will help us to build the movement in a larger way to tell that how restoration of OPS is essentially important in order to guarantee us a post-retirement life which is commensurate with and this is what the guarantee was, that your post-retirement life should be commensurate with your life in service. That is why you are surrendering, you are sort of foregoing your pay at this point in time to avail it at a later point in time. And hence, what NPS did by sort of making it a contributory is that, and making it to the market linked sort of phenomena, was to disconnect that, and it actually then therefore amounts to a pay cut. I hope that I have been able to clarify, Rudrashis, and I will sort of stop here, and I'll ask for wait for the questions.
Thanks a million, Avinash. I must say it was not just lucid. The way you have summarized the operative part of different court judgments, that was indeed informative. And I think all the participants, especially all my colleagues from Delhi University, who are fellow travelers and fellow sufferers of this whole phenomena, where we have been denied the old pension scheme because of delay in our appointments. I think they would agree that this has given us not just hope, but also a resolve to continue the struggle. Before I invite the next speaker, and I would request Surajit to speak first before we take up questions from all the members present here. I just want to. It's not a response to Avinash's. I just want to give an information to everybody present here. The Jyoti Singh judgment, which Avinash quoted in great detail and which has come in July 2024, the petitioner approached the university with that judgment, and she has been told that their university is waiting for the division bench judgment, and after that they're very clear that they're going to approach the Supreme Court. And so is the case with most of the other judgments, where despite getting favorable judgments, the teachers are not getting any relief because the university has been approaching the higher courts to deny the relief. And more importantly, they are constantly quoting some kind of a verbal instruction from the Revenue and Expenditure Department of the Government of India, which apparently has asked the university to always approach higher court and to deny any benefits to the teachers. Right. So this is something which because since I have been following up these judgments and also the concerned colleagues in different colleges, this is the feedback which we have got, not only from the colleagues, but also from the lawyers who have been pursuing this case. We'll take up all these responses later. And I would now request Dr. Surajit Mazumdar to give his own inputs on this newfangled scheme which has come in the name of Unified Pension Scheme. Surajit, the forum is all yours.
Thank you, Rudrashish. I will also use the presentation to make my points. Is it visible to you, the slide?
Yes.
Okay, so Avinash has kind of already laid the context, and if one looks at the kind of amount of litigation that is going on about this matter, and it's got to do with the fact that between being in the OPS and not being in the OPS makes a huge difference. And the huge difference is what makes it an important question for both the potential losers or beneficiaries of that scheme, as well as for the government, which is so interested in thrusting or pushing down a scheme which is different from the OPS on all employees in central and state governments and in autonomous bodies. So there is a certain history to this process, which I would like to briefly draw the attention of everyone to. Something is part of my own personal experience, having joined teaching in 1993 and made the transition from various institutions. I've ended up being part of various different pension schemes at the same time, anyway, over my career. I'm now in the NPS. I began under the OPS in 1993. So it is actually quite remarkable that in 1986, when the fourth SIP Pay Commission recommendations were implemented, actually implemented a couple of years beyond after 1986, for all employees who joined after that, the what we now call the old pension scheme or the pension GPF scheme was made mandatory. Okay, and in less than 2 decades of that, you had this shift to the NPS for all employees who joined service from 1st January 2004 onward. So NPS system has been around for longer than the period in which actually the OPS was mandatory for all employees. So you had this transition taking place from 2004. And the remarkable feature about this transition was it had a certain black magic quality to it, which was that, as Avinash was mentioning, that the transition to NPS implied a pay cut, meaning that what was the obligation of the employer, in our case, either the government or the university, towards the employees, whether during service or after superannuation or retirement. That obligation came down or was reduced, and to that extent, it constituted a pay cut. But the remarkable thing was that the transition from OPS to NPS actually meant that despite the pay cut, the structuring of the scheme was such that it meant that the expenditure burden on the government actually increased for several decades after the implementation of the NPS. Of course, the NPS, when it first came, a large number of people who are today affected by it had not entered service or were still in their early period of their service and not really at that point of time immediately preoccupied with the questions of what would happen when they retire. But over a period of time, as the number of people who have been under the NPS, that proportion within the total category of employees has increased, and as realization has dawned over what the implications of the NPS are, the issue about NPS has started emerging as an important issue, which was reflected in the fact, of course, that in several states, this demand for restoration of, or across the country, demand for restoration of the old pension scheme came up, and in certain cases, some state governments actually decided to revert back to the old pension scheme. So the first part of the story is about what did the NPS mean? Why did it mean a pay cut? So it meant a pay cut because in both, whether you are under NPS or under OPS, in both cases, there is a salary that you would receive during your service. And on that count, it's not that if you were under NPS, you would receive a different salary. If you were under OPS, you would receive a different salary. The salary was the same. You are on the same salary structure. So earnings on the basis of salary were not dependent on the scheme under which you were. They were equivalent. What was different? What was different was the payments that had to be made by the employer for your retirement benefits, what you would receive after retirement. So under the old pension scheme, the in addition to what salary had to be paid by the government or the university, as the case may be, in addition to that, you had to be paid a pension which was determined by the emoluments or salary that you were receiving towards the end of your career, and with, of course, the provision of computation and a family pension system. Okay, so that's the financial obligation that was entirely on the employer. This was a payment that the employer had to make to the employee after the superannuation or retirement of the employee. In addition was the gratuity that people received on superannuation, the obligation for which was also on the employer. So all these three, the salary you received during your service, as well as the other two which you received on or after superannuation, were obligations of the employer. The obligations of the employer, once the NPS comes into force, was reduced to paying into a pension corpus or a pension fund during the service of the employee 10% of the salary, which was the employer's contribution to the pension corpus. So what was 1B and 1C on the left-hand side of this which was the financial obligation that the government or the employer had, was replaced by 2B on this side. And it amounts to a pay cut if 1B plus 1C, its value is more than the value of 2B. And I mean, without going into the details of the calculations, okay, if you compare these two amounts at any given point of time, in the same time, then 2B would be significantly lower than 1B plus 1C, which meant that the total payments that the employer under the NPS had to make to the employee were significantly less than the total payments that would have to be made under the old pension scheme. Okay. So this is what constitutes the pay cut, because the total benefits of that you earn during your service, part of which you receive after you retire, the total benefits were reduced, what the employer had to pay. But the time pattern of these payments under OPS and NPS were fundamentally different. And that is why the shift to the NPS actually meant that for at least 3 to 4 decades after that introduction, the expenditure burden on the government of meeting all pensionary obligations actually increased. It increased because whatever pension had to be paid for all employees who were already retired and receiving pension, or who had joined before 1st January 2004, whenever they would retire and become entitled to pension under the old pension scheme, they would have to be paid that pension. So up till 1st January 2004, those who joined, if you assume 30 years of service for them, they would start retiring only in 2034 onward. And if you say there's at least 20 years of life after that, then for this period till 2054 at least, government would have to go on paying the pension. The transition to NPS made no difference to this part of the expenditure on pensions. The difference it made was to what would have to be paid for those who were under NPS. Okay. But since these payments had to be made while they were in service, it meant an additional expenditure. Any saving on the expenditure of the government that would arise on account of the fact that the NPS amounted to a pay cut would reflect itself in the government's budget only when those who are under NPS started retiring. Until 2034, this amount would be virtually zero. Okay. But in all this period, because they have been brought under the NPS, the employer's contribution to NPS has to be made. So in addition to what pension expenditure the government already had to make, it took on this additional expenditure of contribution to the NPS, and therefore, for at least 3 decades or so, the transition to the NPS actually meant that the government's expenditure burden increased. It was not, in this period at least, a saving of expenditure. It would only have a difference way ahead in the future. That is why you had this peculiar combination where the employees were facing a pay cut while the government's expenditure burden actually increased. And this is the reason why it was possible in many cases to revert back to the OPS, because the OPS meant that this additional expenditure burden would be actually reduced. Okay. Now, so from the point of view of the employer, we see that there was a reduction in the burden. And naturally, therefore, that meant that the returns that would be available to the employee were also going to be affected. So what did the employee get after the transition to the NPS? Under the old pension scheme, when you retired, after retirement, for your rest of your life, you would receive a pension, which was linked to the last the salary that you drew towards the end of your career. Okay, that pension would be for a period of time partially reduced if you choose to commute a part of your pension and receive that commuted pension as a lump sum. The important point, however, also was that that pension was protected against inflation, because DNS allowance was also something that pensioners were entitled to. And every time there was a pay revision, the pension would also get revised. What this meant was that the pension that people would receive would be related to the pay that they drew at the end of their career, not what they drew throughout their career, but the pay that they drew at the end of their career. And secondly, it would be a function of the pay structure that would be prevailing at the time that they were receiving the pensions, not the pay structure that was prevailing at the time when they were employees themselves. So if current employees had a different pay structure from the time that a retired employee was in service, the pension would be reflecting that change in the pay structure. And of course, it meant that the pension amount was indexed against inflation, because against the inflation that is experienced during the retired life of the employee. In addition to that pension, you were entitled to these lump sum payments as commuted pension and as retirement gratuity. There was, under the pension cum GPS scheme, a contribution that the employee made to the General Provident Fund out of his or her salary. But that constituted savings out of the income of the employee, whose accumulated amount the employee would be entitled to at retirement. This had no relationship it was an entirely distinct amount which had no relationship with the pensionary benefits that were to be received from the employer. In the NPS, on the other hand, both the employer and the employee contributed 10%. In the original NPS in 2004, contributed 10% of the monthly salary of the employee into a pension corpus fund, which would be invested in the financial markets, and the accumulated fund at the end of the person's retirement, at the end of a person's career, would then determine what superannuation benefits would be, or post-retirement benefits would be available, because the employer would cease to have any obligation towards the employee once the service of the employee is completed. Because all obligations of post-retirement life which were on the employer was supposed to be met by this contribution to the pension corpus or pension fund. Now, what this meant was that the fund which would determine the quantum of post-retirement benefits you could get, and you could get them in two forms. One was that a part of that accumulated fund could be invested in an annuity from which every month you would receive a certain amount. And a minimum of 40% was fixed for that part. Okay. Now that minimum 40%, of course, was only 10 percentage points less than the part of the pension corpus which was contributed by the employer. So really, the what you receive from the employer was only 50% of that pension corpus. And if that were to be invested in an annuity, what you would get every month, that is what should be compared with the pension you would receive under the OPS to get a sense of what difference it made. The balance amount, which was not invested in the annuity, could be drawn as a lump sum. But whatever lump sum you drew, this was not like retirement gratuity or commuted pension, because 50% of that pension corpus was effectively out of the savings out of your own salary. They did not come from the employer. So that actually replaced the GPF contribution. So the real pensionary benefits that you would get from the employer were limited to 50% of the pension corpus. 40%, that is 4/5 of that, had to be in any case invested in an annuity. But even if you invested the entire 50%, the amount that you would be able to receive would be fixed by that amount. So what it meant is that the post-retirement benefits under the NPS were not linked to the pay structures prevailing during the retired life of the employee, nor linked to the price levels and inflation rates during the lifetime of the employee, during the post-retirement life of the employee. But instead, it was linked to the pay that the employee had received during his or her service as career in the career. So it meant that if you were an employee who had worked in periods in which the economy was less developed, per capita incomes were lower, salaries were lower, then the who would reach a point of time when the pay structures were different and higher. Okay. So it was, it was a system in which this kind of an inequity was inherent, which was not present in the old pension scheme. Once the significance of this shift to the NPS started becoming clear, it was clear that the OPS to NPS transition meant that the amount that you were going to receive was much less than what the old pension scheme would allow you to get after retirement. Okay. Secondly, if you wanted to increase the amount that you would receive as the annuity, then you had to reduce correspondingly the lump sum amount that you could withdraw, because there's a pension corpus. The larger part you put to receive, you have to put a larger part to increase the level of the pension and reduce the part that you can withdraw as a lump sum. Okay. So there was this inverse relationship between these two parts of the retirement benefits. There were, of course, the uncertainties and risks associated with the fact that these funds had to be invested in financial markets, which are notoriously volatile in character. And there was no protection against price rise in the post-retirement period. In some cases, really the first time the implications of NPS started hitting people was in the few cases where the employees died while in service or in an early part of their service, during which the contribution or the accumulation of the pension corpus fund was so limited that it would not be sufficient to maintain their families who would have lost their breadwinner on account of that tragedy. It's then that it started hitting employees as to what was the implications of this transition to NPS. And it started this whole pressure to rest for the restoration of the OPS, and the increasing voice or demand for was restoration of the NPS. In response to that, from time to time, the government has made attempts to try and make the NPS acceptable to people without withdrawing or changing the basic structure of the system. So there was an increase in the amount of the government contribution to 14% while retaining the employees' contribution at 10%. Then death cum retirement gratuity benefits were extended to NPS employees. Okay. In case of death during service, the option of getting a family pension of the kind that you could get under the old pension scheme, that facility was also sought to be created. All of these were basically attempts to make the NPS acceptable to employees to counter this growing demand for restoration of OPS. Okay. And trying to show that the benefits were being increased in such a way as to address those concerns when in reality the cut in the pay as well as the significant reduction in post-retirement benefits were kept in place. And therefore, people were not convinced about this, and the demand for OPS has continued to grow. And it is in response to that pressure that now this, what they call the Unified Pension Scheme, has been announced. One of the difficulties we face in discussing about the UPS is that all the relevant fine print associated with the UPS is not yet available. To the best of my knowledge, even the report of the committee and the calculations that it has done on which this UPS was announced have not been made public. This committee had been constituted last year by the finance ministry, but we still don't know what is the report, what kind of calculations they actually did, which would reveal precisely what was going to come when the UPS was to be implemented in 2025. It is also worth keeping in mind that such lack of transparency about what the UPS will actually mean is perhaps an indication of what are the dangers that lie if one uncritically accepts this UPS as a significant improvement on the existing NPS. But there are certain parts that have already got revealed, which do make it clear that the UPS is far from being a real substantive replacement of the old pension scheme, and very little in it makes a case for replacement of or giving up on the demand for the restoration of the OPS. So let me briefly try and explain that. So the Ministry of Finance Department of Expenditure issued this, what it called the brief on the NPS on 24th August, following the press release and the public announcements about the unified pension scheme that had already been made by the government. And there it set out in a little bit more detail than had been come in the media reports about what was the scheme going to be all about. So the first claim was, of course, that an assured pension of at least 50% of the last 12 months average salary would be something that those under the UPS would be entitled to. Okay. Point to note is that 50% of the last 12 months average salary, even if that is what you're going to get, it still does not mean that your pension will change as the pay structure changes with successive pay revisions. Your pension amount would still be fixed by whatever was the last salary that you drew, not subject to any change in the future. Okay. Minimum pension of 10,000 was announced for those with at least 10 years service, and a family pension equivalent to 60% of the pension would be available to the spouse in the event of the death of the pensioner. And it is claimed that dearness relief was going to be given on the assured pension, minimum pension, and family pension, which means that the claim is that at least 50% of the last 12 months average salary, that which you're getting as pension, would be just as it would for those under the old pension scheme. And in addition, additional lump sum amount to be paid was provided for in this unified pension scheme. So if you see the what they say are the broad contours of the unified pension scheme, you can see attempts to supposedly address the uncertainty about the pension amount that was inbuilt into the NPS because of both the market investment character as well as the fact that what annuities you would offers options available when you retire would determine what you would get. So the uncertainties associated with your post-retirement benefits, this would appear to be an attempt to address that. Okay, and the dearness relief. Okay, the dearness relief is also supposedly trying to ensure that the difficulties because of associated with price rises after you retire are being sought to be addressed, and an additional lump sum amount which you were losing in the process of trying to get a higher pension is being supposedly provided for. But if you look at the further details in that brief, okay, then you see where the catch is. Okay. So if you look at how is all these payments going to be financed or managed, nothing is going to be an amount that is going to be paid out of government's revenues at the time that, so you're not entitled to any pension that is to be paid out of the current revenues. What you continue to have the system where a certain contribution of the employer in your service will be done to build a pension corpus fund, and all pensionary benefits will be paid out of that fund. Now, what has been introduced under the UPS is that fund will now have two parts. One part would be where 10% of the employee's contribution and 10% of the employer's contribution, 10% of salary as employer's contribution would go. That is the individual pension fund. So it's going back to the original NPS pension fund where both employer and employee contribute 10% of the monthly salary. That is what is the pension fund which the employee would now be entitled to decide on between the part that you that you invest in an annuity, again with 40% being the minimum, and the part that you choose to withdraw as a lump sum. The remaining contribution of government, which is to be increased from 14 to 18.5%. So the remaining 8.5% of your salary contribution goes into a separate pool corpus over which the employee has no control or right. It's that corpus from which any additional amount that has to be paid to ensure the so-called assured pension will be financed. Okay. So that fund is not something on which the employee can have any control. Okay. Now the catch here is that the assured pension, which is supposed to be 50% of your last 12 months salary, okay, that assured pension, if you withdraw from the fund, the individual corpus fund, any part as lump sum, then proportionately the assured pension to you will be reduced. So if you withdraw half of that, then the assured pension will be also halved. So you are not actually entitled to a 50% of your last salary, last 12 months average salary as the assured pension. That will be the assured pension if and only if you invest the entire individual corpus, half of which is your contribution from your salary and not from the employer, into an annuity. Then and only then do you have any chance of getting what is called the assured pension. And the amount that you can withdraw from that as a lump sum that is also been reduced. That would also be reduced because instead of the pension fund in which 14% of your basic salary was being paid by your employer, because it is reduced to 10%, the lump sum that you can withdraw from that would be correspondingly reduced because you still can withdraw only up to 60%. So, assured pension only if you don't withdraw from, I mean, the minimum condition is that you don't withdraw from any lump sum amount from your individual pension corpus. And if you withdraw, the lump sum amount that you can withdraw would be less under UPS than it would be under the NPS prevailing before the introduction of UPS. Okay. There is an additional lump sum payment that has been specified, but that would be only a relatively small amount and it would not compensate for the reduction in the lump sum amount that is coming down because the proportion of the pension corpus from which you can withdraw is proposed to be reduced. Now, so even after, so here again you see, this is again from that brief. How will the amount of pension that you are supposed to receive, that 50%, what is this 50% that you are supposed to be receiving? It's not that you will actually receive that 50% even if you invest your entire corpus in an annuity. Because what will be used will be a default or a benchmark annuity, which is specified by the Pension Fund Regulatory Development Authority. Whatever is the difference between the annuity value of that default annuity, monthly annuity, and the 50% that is assured to you, it's that shortfall only that will be made up. So if your annuity is actually paying less than that default, you will not get 50% of pension because the shortfall that is to be covered is limited to the difference between what the benchmark annuity is paying and what the 50% assured pension would actually involve. So even if you invest your entire corpus, you are facing an uncertainty about the actual amount that you will receive every month because it depends on the gap between that 50% and the default annuity value. Okay. And this, of course, is something that you can only get after a minimum qualifying service of 25 years. And if you have less service than that, then the pension, the 50 assured amount itself will be proportionately reduced. And therefore, the amount of shortfall that has to be made up will also be correspondingly reduced. So the uncertainty about precisely what you will get in terms of pension every month after you retire is something that continues to exist even under the UPS. Okay. So what is still not clear are the following questions. Okay. So as I said, one question is clear that the pension that you will receive will be fixed on the time at the time that you retire. The ceiling on the pension that you can get will be fixed at that time. There will be no adjustment if current employees have the benefit of any pay revision. So those who are retiring earlier, before pay revisions, and those who retire after pay revisions, there will be a difference in the pension amounts that they will be receiving. Okay, that much is absolutely clear. Okay. The second question, which is there, which is still not clear how it will be dealt with, is what is the shortfall that they are going to be covering? Will that shortfall actually, because the comparison that is going to be made is between what you would receive as annuity if your entire pension corpus was invested in an annuity with 50% of your last average salary of the last 12 months. It's that shortfall. Now, what happens if someone does not invest that full amount in an annuity? Will the amount of the shortfall that the person gets be also correspondingly adjusted? That is, I have put my entire corpus into the pension fund, into an annuity. I am getting an annuity amount. If I invest less, I get a lesser annuity amount. But will I also get a lesser amount as the shortfall if I withdraw, say, any lump sum amount from the pension corpus? That's still not clear. If there is to be a proportionate adjustment of the, in the case of withdrawal of the assured pension, will that burden be only, will that be only account of the fact that your annuity value will be reduced, or will it also be on account of the fact that the shortfall being covered will also be reduced? That's still not clear. Until the fine print comes, we will not know that. Okay. The signs are dangerous because they have not said that the comparison will be made with the employer's contribution to the pension corpus if that was to be invested in annuity. The amount that is contributed by the employee is also to be incorporated into the calculation of what is the shortfall. So the contribution of the employee to the pension fund, okay, is is something that is almost mandated by this system. Okay. The second thing will be that if that's a separate corpus, which is to be maintained independently, where the government's 8.5% of your salary contribution goes, how will this movement of funds, if there is shortfall, how is that to be covered? How is that movement going to take place? What are going to be the procedures for that? How is that amount going to be calculated? And the procedures for that both are somewhat uncertain based on what we are currently have available. Then there's this question of how is the inflation compensation to be done? The annuities themselves are not price indexed. At the time that you invest in the annuity, the amount that is fixed is given. You can think of an annuity as something which is the reverse of borrowing with an EMI. When you borrow from an institution, a certain amount, say to buy a house, there's a calculation which says over 20 years, 30 years, whatever it is, how much amount is to be paid to you, paid by you to the bank every month. Okay. If you reverse that, then you get a sense of what an annuity is. That you put, instead of borrowing from a bank, you lend to a financial institution, which then pays you an EMI for the for a certain, or for the rest of your life, or for a certain period of your life, a certain defined number of years, such that the amount that you have given is repaid to you. That's what really an annuity is. So the amount is fixed. That annuity amount doesn't change with changes in prices. So in principle, the shortfall should be adjusted as this happens. How will that be done? And what happens if the individual, the separate corpus fund is not adequate to cover for that kind of a the shortfalls that arise on account of inflation? This is again something that is not clear. Okay. But what is clear is that the unified pension system is not a unified pension system. It is not a marriage between the NPS and the OPS. It is very much in the NPS mold. It is structurally the same. It still retains the characteristic of ensuring that the employer's contribution to pensionary benefits, the quantum of it over the entire career of any employee, will be less, and it continues to exhibit the characteristic of giving inadequate post-retirement benefits to an employee, which would allow them to lead a reasonable life commensurate with the lives of others who are in service at the moment, and with the life that they had during their service. And to that extent, the UPS, even if all these questions come to be clearly answered tomorrow, the demand for the restoration of the OPS, there is no reason why that demand should be at all withdrawn or amended in the light of the UPS. Thank you.
Thanks a lot. Thank you indeed for that very, very, lucid and illuminating presentation. In fact, I must say a lot of the unanswered questions on UPAs have been addressed by you, notably in terms of, addressing the question of the shortfall, also looking at how the adjustment of the expenditure, and more importantly, the fact that what is the fate of the employees' contribution, the fact that there is a provision in UPS which says that only 10%, only 6 months of the last drawn salary will be paid as lump sum to the employee. So that, in fact, so a rough calculation we have seen where by which almost 95% of the employee's contribution is being taken away. Unlike NPS, where the employee's contribution would, theoretically, the possibility of coming back as part of that 60% lump sum which the employee gets. But even that option is not being given to the employee in UPS. So I would now expect the participants to have their questions for the panelists after these two excellent presentations. And, a lot of, I suppose, individual queries can also be answered by our two panel. And both Avinash and Surajit, they have tried their best to make sure that complicated concepts are being given in a very lucid manner, especially to people like us who are uninitiated into this world of money. Yes.
रुद्र, मेरी आवाज आ रही है? मैं डॉक्टर रीता नामदेव, बीएनसी
हाँ,
कॉलेज।
बोलिए रीता जी, बोलिए
जी,
रीता जी।
मैंने काफी डिटेल में सुना दोनों ही वक्ताओं को। मैं हिंदी से हूँ, हिंदी में सोचती हूँ ज्यादा, हिंदी में सोती जागती खाती पीती हूँ, तो हिंदी में बात कर रही हूँ। और मैं बताना चाहती हूँ कि जितनी जानकारी मुझे चाहिए और जितने सारे प्रश्न हैं, तो वो मेरे सॉल्व नहीं हुए, क्योंकि टोटली लेक्चर इंग्लिश में था, बाइलिंगुअल भी नहीं था। तो मैं चाहती हूँ कि मेरे जो कुछ प्रश्न है तो उसमें मुझे ब्रीफ किया जाए। मैं नहीं समझ पाई कि अभी जैसे हमें भरना है कि हम ओपीएस भरें कि एनपीएस भरें, क्या चूज करें। तो एक तो हमें क्या करना चाहिए, इनमें डिफरेंट कितना है, हमारी सैलरी पे कितना अंतर पड़ेगा। आज 15 साल बाद अगर हम इस कोई दूसरी पेंशन स्कीम में जाते हैं तो अभी तक जो हमारा फंड कटा है उसका क्या होगा, और कौन सी पेंशन स्कीम है जो रिटायरमेंट के बाद बेनिफिट देती है ज्यादा बेटर, और कौन सी पेंशन स्कीम है कि हम पूरे रिटायरमेंट तक जॉब नहीं करते हैं, हम 15 साल 20 साल करके चाहते हैं कि अब हम सर्विस ना करें, तो वो ज्यादा बेनिफिट है। इसी तरह के बहुत सारे प्रश्न हैं मेरे दिमाग में। तो मैं चाहती हूँ कि कोई भी स्पीकर हिंदी में थोड़ा मुझे ब्रीफ करे, और एक आध क्वेश्चन और मतलब मेरा रह जाए तो उसे भी करे, ताकि मैं भी कॉन्फिडेंटली अपना निर्णय ले सकूं। ये बीच बीच में अंग्रेजी के शब्द आना अलग बात है, पर पूरा अंग्रेजी में समझ पाना दूसरी बात है। तो प्लीज।
मैं इसका जवाब दूं?
हाँ, कोई भी, मुझे तो
हाँ।
संतुष्ट होने से
नहीं, मैं
मतलब है।
मैं अध्यक्ष से पूछ रहा हूं।
हाँ हाँ, बिल्कुल दीजिए।
हाँ
जी प्लीज सर।
हाँ। तो अब दिक्कत यह है कि हिंदी अंग्रेजी का
मुझे आवाज
हमारे
नहीं आ
सिस्टम
रही
में
है।
यह दिक्कत रहता ही है। अगर कभी अवसर मिले तो पूरा हिंदी में भी हम इसको आपके सामने पेश कर सकते हैं। लेकिन आपका जो सवाल है उसका जो साधारण जवाब है कि पहला तो ये स्पष्ट रहना चाहिए कि ओल्ड पेंशन स्कीम जो है, पुरानी पेंशन स्कीम जो है, उसका एनपीएस या उसका जो नया रूप यूपीएस आने वाला है, दोनों उसके विकल्प नहीं है। इसलिए हमारी जो मांग है कि वो पुरानी पेंशन स्कीम फिर से बहाल की जाए, वो मांग जो है हमारे आंदोलन की मांग, उसको रहना पड़ेगा हमारे आंदोलन का एक मांग के रूप में। जहां तक यूपीएस और एनपीएस के बीच में जब कोई चॉइस करने की बात आएगी, वो तो 2025 में आएगी। और जब आएगी तब हमको स्पष्ट होगा कि यूपीएस में के अलग अलग प्रावधान हकीकत में क्या है, और जिन लोगों के का सर्विस 25 साल से कम है उन पर क्या असर पड़ेगा इस एनपीएस से यूपीएस में जाने के लिए से, वो हमको तभी पता चलेगा जब इसके डिटेल्स जो हैं, जो अभी हमें उपलब्ध नहीं है, वो सरकार स्पष्ट करेगी। अभी तक स्पष्ट नहीं किया है सब कुछ, और क्योंकि स्पष्ट नहीं किया है इसलिए अ, ये अपेक्षा की जा सकती है कि बहुत सारी चीजें बाद में निकल के आएंगी जो शायद अभी उनके अपने प्रस्तुति में स्पष्ट नहीं है कि इस यूपीएस के परिणाम क्या होंगे। तो वो जब डिटेल आएगा, उसका जब हम विश्लेषण कर पाएंगे, तब कुछ सवालों का और जवाब निकाल पाएंगे। लेकिन हमारी कोशिश तो यह है कि हमको ये सवाल में जूझना ही ना पड़े कि ये यूपीएस बेहतर है और एनपीएस बेहतर है। अगर ओपीएस वापस आ गया तो ये सवाल ही अपने आप में इसका कोई अर्थ नहीं रह जाएगा।
शुक्रिया। रीता जी, आपको कोई और प्रश्न है? नहीं तो हम आगे बढ़े। Any more questions from the participants? I suppose there should be many.
Yes, yes, sir.
हाँ
Can I
अनीता जी,
speak?
हाँ हाँ
हाँ
प्लीज।
जी. Sir, I am Dr. Anita Rani from Dayal Singh College. Sir, मुझे थोड़ी सी confusion ये है that I joined Daulat Ram as a guest in 2002 and I taught there till December 2004. In December 2004, I got permanent in Dayal Singh College. But the post on which I got permanent, it was already notified in 2003. उस पे ऑलरेडी एक अडॉक पढ़ा रहे थे पहले, वो ऑलरेडी एडवर्टाइज थी जिसपे मेरा अपॉइंटमेंट हुआ था। क्या मैं इस उसमें कैन आई डू आई कम अंडर दिस कैटेगरी दैट आई कैन ऑप्ट फॉर ओपीएस?
Avinash, would you like to answer that?
Yeah, very much. अनिता जी, ये तो दिस इज वेरी क्लियर जो मैंने आपको बताया, जिसका जिक्र मैंने मद्रास जो पंजाब और हरियाणा हाई कोर्ट के रेफरेंस में मैंने बताया था कि अगर आप उसके जजमेंट को पढ़ेंगे तो उसमें ये क्लियरली बताया गया है कि अगर आप आपने अप्लाई किया और आप वहाँ पर पढ़ा रही हैं पहले से, और अगर आपका परमानेंट वहाँ पर एब्जॉर्प्शन बाद में होता है 2004 के बाद भी, तो आप तो बिल्कुल उसके लिए आप न्यू एंट्रेंट की तरह तो ट्रीट नहीं की जा सकती हैं। अब जहां तक गेस्ट,
आई वाज टीचिंग एज अ गेस्ट इन दौलत राम कॉलेज, आई गॉट परमानेंट इन दयाल सिंह कॉलेज, सो उसका है मुझे थोड़ा सा कंफ्यूजन सर।
हाँ, जो
बट
गेस्ट
इनका एडवर्टीजमेंट पहले का है ना।
जी जी बिल्कुल।
हम्म।
तो आपका चूंकि वो 2003 का एडवर्टाइजमेंट है, तो आप जो उनका अभी जो सर्कुलर आया था डीओपीटी का, जिसमें उन्होंने ये बेनिफिट बाकी गवर्नमेंट एम्प्लॉयज को दिया है, और अभी वो आर्ग्यू कर रहे हैं कि अभी हमने ऑटोनोमस बॉडीज और यूनिवर्सिटी को नहीं दिया है, तो आप तो क्लियरली उसमें फॉल करेंगी। और इसलिए मैं वो कह रहा हूं कि जो अगर ये सपोज करिए कि 2003 में आया ये एडवर्टीजमेंट, अगर 2002 में और 1 में ही आ गया होता तो शायद आपने तब भी अप्लाई किया होता। तो जितने भी एडवर्टीजमेंट्स लेट आए हैं, और अगर
और सर अगर ये एडवर्टाइजमेंट 2004 में आया है बट पोस्ट ऑलरेडी नोटिफाइड थी, तब भी हम उस कैटेगरी में फॉल करेंगे?
जी, उस नोटिस को आप पढ़ेंगे तो उसमें लिखा है कि पोस्ट नोटिफाइड और एडवर्टाइज दोनों ही बातें मेंशन है। तो अभी तक इन्होंने ऑटोनमस बॉडीज में इन्होंने नहीं लाया है और कह रहे हैं कि हम नहीं लेकर आए हैं, बट एक्चुअली मूवमेंट की डिमांड तो ये होनी चाहिए और है कि वो जो डीओपीटी ऑर्डर सर्कुलर है वो यूनिवर्सिटीज पे भी इम्प्लीमेंट होनी चाहिए। क्योंकि पहले आपको पता होगा कि दिल्ली यूनिवर्सिटी में सभी कॉलेजेस में कई लोगों ने कितने महीने लगा करके अपने कॉलेजेस का एडवर्टीजमेंट खोजा, लाइब्रेरीज गए, वहां के नोटिफाई देखा, वो नोटिफाई कब हुआ, ये सारे रिकॉर्ड्स निकाले, और अचानक से फिर इन्होंने दे टुक इट बैक। तो इन दैट पर्सपेक्टिव ये बिल्कुल आना चाहिए इन द कॉन्टेक्स्ट ऑफ द इन द अंडर ओपीएस।
सॉरी, मैं लेफ्ट हो गई थी और ज्वाइन भी नहीं कर पा रही थी, थोड़ा टाइम लगा मुझे, तो पता नहीं, शायद आप भी समझ गए होंगे, मैं लेफ्ट हो गई हूँ, तो मेरा आंसर पेंडिंग रखा होगा मेरे लिए।
रीता जी, उन्होंने
जी
आपका आंसर क्या है? तो
जी।
उन्होंने ये कहा है कि जब तक आपके ये नोटिफिकेशन नहीं आते, 1 अप्रैल 2025 से यूपीएस लागू होने की बात हो रही है।
अच्छा।
अगर ये अब लागू, उसके बाद उसके जो डिटेल्स आएंगे, उससे हमें
हम्म
इंडिविजुअल केसेस को देख के ये समझना पड़ेगा कि किन के लिए कौन सा फायदेमंद है। बट दोनों, मतलब ये बेसिकली फायदे की कोई बात है ही नहीं।
हम्म
एनपीएस और यूपीएस दोनों एम्प्लॉय के लिए नुकसानदायक है। और मूवमेंट का ये तकाजा है, मूवमेंट को ये जारी रखना है कि सबको ओपीएस मिले। वो हमारा टारगेट है, वो हमारा गोल है। और जब यूपीएस का डिटेल्स आएगा, तब हम तय तय करेंगे कौन सा किसके लिए बेनिफिशियल होगा।
तो ये जो कॉलेज मांग रहा है कि अभी भर के दो, मेरा कॉलेज मांग रहा है, उन्होंने मेल किया है कि ये बस 27 दिसंबर तक भर के दो, तो अवॉइड कर सकते हैं?
नहीं, यूपीएस के बारे में तो बोल ही नहीं सकते, क्योंकि यूपीएस के बारे में अभी तक कुछ दिया ही नहीं उन्होंने।
मैंने
अभी तक
पूरा भर
गवर्नमेंट
परफॉर्मा पढ़ा नहीं है, लेकिन उसमें मुझे लगता है कि
उस वो
इन्होंने
आप
ऑप्शन दिए हुए हैं।
वो दूसरे चीज का होगा। आप ऑप्शन शेयर कीजिएगा तो हम लोगों से, तो हमें पता चलेगा कि
अच्छा
क्या ऑप्शन
ठीक
है।
है। ओके।
नीनू, यू हैव अ क्वेश्चन?
Yeah, hello everyone. Professor Neenu Kumar, Department of English, Aditi Mahavidyalaya. My question is the same जो पहले सवाल ये पूछा गया है कि अगर एनपीएस ओपीएस में कन्वर्ट होता है तो जो हमारा कंट्रीब्यूशन है एम्प्लॉय एंड एम्प्लॉयर, उस कंट्रीब्यूशन का क्या होगा? What will happen to that amount which has already gone to a corpus under NPS, both from the employee and the employer, if we get OPS? Thank you.
You
Yeah,
want to respond to
yeah,
that?
yeah. So it would logically what it would appear to be there is that whatever is your corpus at the time that suppose you make a transition from NPS to UPS, in that
OPS.
corpus, in that
OPS.
corpus,
OPS. No. NPS, suppose we get OPS.
oh, if
If
you
we
get
get
OPS,
OPS. Yeah,
if
that's
you,
what I said.
yeah,
OPS.
if you get OPS, then whatever is your contribution to the pension corpus is something that you are entitled to, should be entitled to, because that is something that has come out of your salary. Okay. And if the pension is to be paid to you, then the employer's contribution to the corpus, whatever, has to be replaced by the employer's payment of pension. So that would logically accrue to the employer itself, that the employer has to pay the pension. But your own contribution to the pension corpus, because it is a payment or a saving out of your salary, that is something that you would have to be entitled to if there is a transition from to back to OPS.
Thank you so much. Thank you. So the employer's contribution will then be converted into pension.
Yes.
Thank you. Okay. Thank you.
Yes. Next question.
Geeta, you wanted to ask a question?
Yeah. Regarding continuity of service, for many of us who were ad hoc, there was a break in, the colleges would not give us an appointment the next day. There was always a break, 1 day, 2 days, or whatever. So will that be regarded as continuous service?
Yes.
Avinash?
So exactly. So all these appointments, all these cases which have petitioners, those who have gone to the court, they were all teaching on the same ad hoc services or temporary services, and there is a sort of a even in the continuation, counting of past service that has happened, all this has been treated as a continuity in service. Now
Right.
that is something that has to be contested and has to be argued. As I said, any narrow definition cannot be applied when you are trying to count for the pensionary benefits of employees, right? So if you are only trying to say that okay, there is a 1 day service gap, That gap was given, but probably in most of the colleges, even in that one day, everybody keeps teaching. Nobody goes
Yeah.
leave, right? So it's about arguing that and establishing that it's a continuity in service. They have been saying is because at that point in time you were ad hoc, and ad hoc rules are governed that you have to give a 1 day gap. But that
Yeah.
1 day gap is a continuity of that service because you have been made permanent in the same post, in the same service, either in the same college or in the other college. So
Right.
that's the broader definition that the courts have actually allowed that space, but the state is not ready to, and the institutions are not ready to accept it. That's what we have to fight.
So in continuity, because when we were serving as ad hocs in 2003 and got permanent in 2004, so we were given a letter which stated that your services are no longer required prior to the interview for the permanent post. That 1 day gap, we were given that letter from the college. My college also gave me a letter saying that my services are no longer required and that I have to appear for the interview before a board. So what you're saying is that that has to be contested, and that should be taken into account, that I was in, but I didn't, I technically did not teach on that day.
No,
I technically did not teach on the 3rd of November 2004. My interview was on the 4th of November 2004. I was given the letter on, I don't know whether I was given the letter on the 2nd or the 3rd. I actually don't remember.
Yeah, the point is that what the courts are arguing is that if you want to understand the qualifying service, what should be counted as a qualifying service, that of course when you are ad hoc, you will be governed by what is governing the ad hoc rules, right? How ad hocs are appointed. The point is about the providing a service to the college or to the institution, which is no different from a regular service, right? So you have been in that service for a longer period of time. So in the same post with a day gap of 1 day, you have been serving that. That's how all the contractual employees are also governed, because you have a new contract. So your previous contract, they will write that in the previous contract has nothing to do with the new contract. So that sort of may come. But if you look at the petitioners in the first case, in the first petition, which the order was given in 2023, the petitioners there have been teaching since 1996. So if they have been teaching since 1996, they also have been governed by the same rules of ad hoc appointments and temporary service and leave, against leave vacancy. So all those have already been taken into care when they have given this judgment. And what we are saying is that if you look at the including the Supreme Court's own interpretation of the pension rules, it says that temporary service or the nature of the service as temporary does not amount to the exclusion from the Rule 13 in term for the counting of the qualifying service. So that's the point that we should take away from the court judgments, and that's what they are finding it difficult to sort of accept, and they are trying to contest. But as far as the court orders that we have just now said, and all the court orders that were quoted in the judgment which I was referring to, they have actually explained it. No ad hoc service can actually be said that okay, you have taught for 9 years and all these 9 years was never renewed, your ad hoc was never renewed. In any renewal, there will be a break in the service because you are governed by the ad hoc rules. You're not governed by a regular service. So that actually should be sort of understood as the broader definition, broader understanding of how Rule 13 of the pension rules for the counting of the past service as qualifying service should be counted. That's the point.
Okay. Thank
Thanks,
you.
Avinash.
I think Tara has a question. Tara raised her, she just, I think, on the chat. Tara, are you there?
Hello, Rudra. Am I audible?
Yes, you are.
Thank you so much, Rudra and Professor Dev, for having Professor Mazumdar and Professor Kumar on the panel and explaining things to us in such clarity. Mine is a slightly different case. Sir, I joined in 2006 without having any prior experience as a guest or an ad hoc in Delhi University, coming from Himachal. And my post is ST, scheduled tribe. So college is not in a position to give us any clarity whether the post was advertised earlier. If this is a post, which was prior advertised and notification, something, the things which is needed to proceed if I am also falling into the OPS. How to and where to get the clarity from, sir?
What was your service in Himachal?
Sir, I directly came here in Delhi University from a school. Himachal was a school job, sir. I was teaching there as a as a para teacher. I don't know if the term is even heard of here. It was a para teacher there. The post was a para teacher. That was in 2004. But the
Okay.
service broke because I left within 1.5 year in Himachal and joined Chandigarh again, Chandigarh Academy, Language Academy, for some 5-6 months before getting permanent here in 2006.
So when was the post you were appointed against advertised?
So that is what the clarity is sought, because college is not giving us any clarity. So when was the post advertised? When was the notified? Because I was in village, and my letter also did not come from college. I had cleared my UGC net, so the letter had come from the UGC uh, on behalf of the college.
Could you clarify from your college that when did they first implement, reservation roster in the college?
I will take note of it, Professor Kumar.
Because if it is an ST post, then it is certainly going to be a backlog post. Because
I am
certainly
sure, sir, but
reservation did not, was implemented in 2006 in Delhi University. It has been there since.
college is having no clarity. College says they don't have any such details. So what to ask from the college? If you could just tell me in one sentence or a word, so that I can just put it across the admin.
Yeah,
Can
so the
I
point,
add here? Yeah, so actually the PWD roster, where you have to list every vacancy, and it is a roster which just vacancies continue to sort of you every time there is a vacancy because anybody leaves or retire, they are just tagged one. You have to just keep rolling it. I think that is the place where Tara will find against which vacancy she was appointed, and one will have to see. I think there one can get a clue. When was that vacancy created? Was it a fresh vacancy? Was it because of retirement of some other teacher? So I think PWD roster may give you some idea of that.
Thank you so much, Professor Habib. I will take note of this. And where to get how to get back to you too, sir? Do you have any mail IDs so that we can, keep this this information in the loop?
so we will
So
put our
where,
IDs on the chat.
all right, sir. Thank you so much. Thank you so much.
Avinash, I wanted to ask this question because on behalf of many teachers, so
Yeah.
do you think it makes sense that we all start the process of filing litigations? That we all start the process of filing means that we first bring this judgment into the notice of the our current employer, I mean to the principal, to the governing body, then to the vice chancellor, and then start the process of approaching High Court for relief. Many of us who became permanent in 2004 or 5 because there was a brief period when there was freeze on jobs around 2002. Appointments did not happen. So many of us are taught on ad hoc basis. So I think for any kind of litigation, there has to be a paper trail. So what do you suggest we start doing? Because that may help many people to organize their paperwork towards it.
Yes, absolutely. So I think that's very important that, first representation should be put to the college, to the governing body. And in most of these cases that, you will find that, all these petitioners have actually exhausted those things that they have written to the governing body. In many cases in Punjab and Chandigarh, the governing body actually endorsed their decisions that yes, they should be covered. And even that was, kind of returned. Even in Hindu college, in the colleague that is a litigant in one of these petitions, the governing body had actually endorsed the decision, but that was overturned by the university. And the court has really said that this is this suddenly, where is this university administration trying to see that it was a mistake, and it will not do when the governing body has endorsed that, and the governing body is right in endorsing it. So please write representations to the the governing body, to the college, and then of course which will then be sent to the university, and with using these judgments saying that, and then subsequently these judgments could be used, and litigations could be subsequently filed. All this should be planned in a way that it can lead to, as I'm saying that Jyoti Singh, I mean it also, a lot of things depends upon who the bench is, and Jyoti Singh seems to be a good judge in that seat as of now. But since the division bench, and as I
She's
said,
been a
all
service lawyer herself, so
yeah,
that was her field.
yes, she was a service lawyer and now is on the service bench, so she understands it. But she has given enough ammunition to sort of, for everyone's protection, two successive orders, and more than two successive orders. There is an order in Jamia also, as I pointed out. So we must use this, write representations to the governing body, to the college principal, and then to the university, using these things, and then get ready for litigation, and to
I
and
think wherever applicable, representation should be made with reference to the relevant court orders
yes,
and the Supreme Court's recent
yes, but yes,
reiteration of the position that once a government employee has been granted relief
yeah,
by the court, then any other employee similarly placed should not need to approach the court.
yeah.
The same benefit should be extended without requiring a fresh approach to the court. So, with reference to these two, representations can be made to the college and with a copy to the university.
Suhasini, you had a question regarding the institution, right? Suhasini, are you there? Anyone else?
Yes, I have a question. I'm Dr.
Rima,
Reema.
yeah, Rima, please go ahead.
I'm Dr. Reema from Talatram College. I missed the part which Dr. Avinash said. So one request is that if you could share this recording, I could listen to what was said and understand. My specific case is that I am in the university system from 1996 onwards. And from October 2002 onwards, I have continuous service, and I got permanent in 2006. So what would be my situation given the information that you have?
Your situation is already very clear, as you are saying that you are in continuous service since 2002.
That includes temporary and ad hoc without any break.
Absolutely. So if you read this judgment, the recent judgment in 2024 was exactly the same judgment, that it was temporary and ad hoc without any break. And then Jyoti Singh simply quoted the previous judgment and gave us same relief. So if you go to the court, you will get the same relief. It's just that you may have to do those representation and to your governing body, to your college, and then go using the same judgment, as Surajit was just pointing out, that you use these two judgment orders of the court, saying, write a representation to your college that I have been in service, my service is in continuity, so therefore I cannot be treated as a new entrant in the new pension scheme. My case is to be treated in the old pension scheme, and these are the court orders on that. And please implement that, and please take their opinion on this. If they do not, if they deny you, that becomes the ground for you to challenge it immediately.
If there's no break at all in between 2002 and your permanent, then your case is very clear.
Absolutely clear.
There is no room for any doubt then.
Okay, I'll then talk to my college and see what response they give. if they will send my file to the university in that case. The university will have to give a response regarding this.
Yeah,
Yes. So when you give your representation, include in your representation the court orders,
yes.
Okay.
so that when they are considering the matter, they are aware of they have to take into account the court orders that are there.
Right. Thank you.
If there is there any more question?
I just wanted to clarify one thing, that as a strategy, one could also try and look that if there are a large number of people from different colleges in the same capacity, then there could also be a different strategy devised for, instead of, so these the sort of mechanism strategy that we were saying is about the individual cases. But if you want to do it as a mass scale and there are a lot of people and want to appeal, then there could be a different strategy for that, and that could be discussed, in a different.
Yeah, good idea.
Avinash, there actually, in terms of numbers, if we club the different categories of new entrants before 2004, the number would be almost 1,500 to 2,000 in Delhi
That's a
University.
big number.
Right. So I think that we should already prepare ourselves for that kind of a strategy where a collective action can take place. But
Yes.
this collective action will be like, some kind of an independent initiative outside the current, duty leadership, because that leadership is not going to take this matter up at all. In fact, they were instrumental in scuttling this kind, the notification which came, which gave us a window room.
Yeah.
They did not help us at all. So I think we need to mobilize teachers and we need to do it.
Yes.
If there is no other question, I can request Dr. Rajiv Ray to give his inputs on the matter. Rajiv.
Yeah, I am there, but ask Professor Mitra, because he had given a comment that he wants to make see the message. RP Mitra, please. Yeah.
Please, Dr. Mitra, if you can. Dr. Mitra is from the Department of Anthropology, University of Delhi. Is he here?
I think he may have left.
Oh, acha. Rajiv, you please speak.
Yeah, speaking is a difficulty, but thank you, both Avinash and Surajit. Thank you very much. This would not be a final comment as such, but I presume our task is cut out, and I see it in 3 levels. Both you and Surajit, Avinash, you please give in your comments, which I would want you to give. I see this at least 3 levels. One is the broader movement to restore back OPS. Okay. The second is the relief which is already available to government service holders. And the third is that few amongst us would still not get covered through the relief that has come up. Okay. Because of specific, the cases that, maybe what Subhashini was trying to say, or I think it was Anita's case, there would be certain, interpretation, or even what I think Geeta was trying to, allude to. This whole concept in the Dalip Kumar's case, which you had, of course, taken up, Avinash, on the issue of what should be regarded as uninterrupted, service. I think it has been made clear, even casual vacancies were taken up to be, and they were given the advantage and given pension in those cases, including Madras High Court, in the Punjab and Himachal High Courts. So I think that is not a problem. I don't see a problem because most of us in Delhi University had worked in an ad hoc capacity. Okay. Uh, I see an issue coming up in certain cases where maybe it got notified, okay? It got even advertised, but the roster changed. So maybe 4 or 5 people got appointed, but in a different kind of a roster. And then maybe later on, maybe in 2007, 8, another vacancy came up and people were taken in. So there is always a possibility that if we don't win the first case, that is OPS to all, then the second and the third things comes up. You know, the relief to the teachers which the central government got, and the third is the process of court cases which we may have to go, even if we get this relief from in the initial phase of the court cases of teachers, based upon especially the Archana Verma and other cases, and Ravindra and Mishra case of 25th July and 19th May. Okay. So it has to be a three-pronged strategy, you know, I would want. So one is teachers have always got, because it has to be some kind of movement must be on the streets. That has to be, the demand has to come up over there. Second, the government has to, and the government UGC and the Department of Expenditure, which today plays the most important, especially the Finance Ministry, plays the most important role in even if you have one post or even 1 rupee to be got, they need an approval from the expenditure unit, which is playing very strict, which is being strict over here. And I think we have missed a bus in the last year or so, where many teachers were even given in. I know of 5 employees, not only teachers, employees, they were given pension, and now it has got stuck up. Okay. And that had happened, I think, in around 31st December 2021, on the initial order which was made for the central government employees, which got taken back. The revised edition got taken back just before the elections last year. So I think we have a task cut out over here. Restore the movement on OPS, because जैसे Rita Namdev ji may have left, but I think until and unless this details of the Utpatan scheme comes up, UPS scheme comes up, I mean, it will be impossible for Surajit to even predict at this moment, you know, which one will suit, because every case will be different. And if somebody retires before 2029, then the calculation may be slightly easier, a proportionate amount. If somebody is retiring before 31st July 2025, and the services, even if somebody joins in 2004, it is only 21 years, you know, 80% of the last drawn salary. So that makes it to 40%, nearly that. So I think our task is cut out, and the demand
Rajiv,
for
I can make one suggestion
yeah,
in
please,
relation to what
please,
you were
please.
saying at the end,
Yeah,
which is on the PFRDA website.
yeah,
There is you can get quotes for annuities
yes.
under NPS.
Mm-hmm.
Okay. So you can enter there a hypothetical person who's reaching 65 now,
Yeah,
and a spouse with a similar age, those details, and enter the NPS corpus amount, the corpus amount that is being invested in the annuity,
yeah.
and get a result of what will be the annuity values that are offered by different annuity providers.
I have
That
already
will
done that. You
that
want the
will give
figure? I
people an
can.
idea of how much is the difference between pension and NPS and
Yeah,
annuity.
the difference at times is moving on to, it depends whether you have got your, you know, if you have taken your promotion in, say, 2005 and got 9 years of ad hoc service, then you may be around 1.25 crores at this moment, the whole fund. Otherwise, if I may divulge a number, there are people, I'm not naming them, who are already in this group. As far as 31st March 2024, the figure of those who have reached a professor's level uh, is just over 1 crore, 1.05 crore. That's the maximum level from the colleges in South Delhi where people have reached on March. And no pension, especially with the 40%, nobody is going over 50,000 at this moment, because the
Yes.
annuity rates, as you have mentioned already, is around 6% and below at this moment. And today the pension at the highest level is around 1,60,000 at this moment. So that is the kind of difference people are looking at.
Yeah, it's
So
1.09 lakhs if you're retiring at the maximum of the professor scale.
yeah, two lakh
The
eighteen
basic
thousand one
itself is,
hundred.
and then there's DA on that. So,
Yeah, and D on that at 53%. So no
and
hypothetical. I've worked
you
it on
need to
real
invest one
numbers.
and a half crores to get this as an annuity. Forget
Yeah,
about the DA part.
no, because it is only uh, you. I'm just holding it that you'll have only 50 lakhs at this moment if people are retiring now. Mhm. Anyway, so the difference is huge. I'm not naming, a friend from economics, which many of us know was retired last January, or this January to be precise. The pension that one is getting with only 20 odd years of service is a pittance. Mhm. Less than the number that I'm quoted to you just now, because his corpus was was less. I see somebody has already.
Suman Lata from Adgi, she wants
Yeah,
to ask.
yeah. Sumanji, you say I'll just add a sentence after that, and maybe Abha and Rudra can. Yeah, Sumanji, आप बोल लीजिए पहले. You wanted to say something. You can unmute yourself.
Suman, are you there? Or do we proceed? Ava, can you help her?
Suman is saying that she's unable to unmute.
Anyway,
I think it would be sad.
in fact, we can.
Yeah,
She can type her question in the chat box.
yeah, yeah.
Suman, you can type your question in the chat box.
I think she wanted to make a comment, not ask a question.
Even the comment can be typed in the chat box.
Okay, if there is no more question, can we call it a day? Abha?
Yeah, this has been a very useful session, and we have recorded the whole thing, and we are going to upload it on the YouTube for the benefit of all teachers who could not join here, not only from Delhi University but across the country. So that is what we are going to do. With that, thanks a lot, Surajit. It was very, very useful. And Avinash, your whole presentation gave us a lot of hope, and there is a lot of work which we need to do, and we will try to organize teachers and try to help them with the format of the presentation representations which they can make. So it will help us if you can email your PPT to us, because it has reference to all court judgments. I've with this link of the talk, we've already circulated judgments, but I think your presentation had many more judgments. So we will share it with our colleagues. Suman Lata is writing, not a question, but wanted to share that I'm getting 19,000 under NPS as pension.
Terrible.
Yeah, that's the
Yes.
state that one is in.
कोविड में जो हमारे कुछ कोलीग्स की डेथ हुई तब से बहुत क्लियर हो गया कि एनपीएस इज नॉट अ स्कीम इन विच वन वांट्स टू बी because even when people had retired as professors, people got 15,000, 14,000.
Yeah.
So, as Rajiv has already said, that our larger movement to make get OPS for all. I think apart from fighting for us smaller groups, it has to be OPS for all. Thanks a lot. Rudra?
Thank you. Thank you.
Thank you.
Before we conclude, I just want to continue with what Surajit said. When NPS came in 2004, after a long gap of, when there was a freeze in employment, UPS came in 2024 when there was a huge freeze in employment both in the university system. And the funny thing was, it took government 20 years to realize NPS is not as economical as it thought. So it has now got UPS. Very soon we will see UPS is a much worse form as compared to NPS. So we have to do that homework and then we have to proceed accordingly. I think that is the political task which we have at the moment. With that, thanks a million to both Avinash and Surajit for their excellent performance. And I must say, this will give us enough ammunition now to take the movement to the next step. Thanks a lot.
Thank you.
Thank you. Thank you, everyone.
Thank you, Surajit, Avinash, Abha, and Rudrashi.
Thank you.
Thank you so much for
Thank you.
initiating.
I'll share you the PPT and all the other court orders.
Thanks a lot. Okay.
Thank you. Thank you.
So much. Good night, everyone.
Good night.
Good
Good
night.
night.